Hello, my name is Craig Cook, and I'm coming to you today from the law offices of Craig O. Cook, and I want to talk to you a minute about medical malpractice cases. Particularly, what should you do before your first meeting with a lawyer on a medical malpractice case concerning a fall, sepsis, or bed sores? Number one, bring any and all pictures of the person that was injured or has the malpractice against, that had the malpractice practiced on them, in other words, not cared for. As I've spoken in other topics and other videos, picture's worth 1,000 words. Pretend that you're in grade school and show and tell. If you don't have something to show, you don't have anything that you can clearly tell the rest of the class, the same way at the jury trial, as well as an adjuster. If you've got pictures showing things, you can tell the adjuster to convince them to try to come up with a reasonable settlement, or you can tell the jury what has occurred in this case, and they can see it with their own eyes. Very, very powerful, very, very important. These pictures go in regards to the bed sore situation. If a patient is septic, sometimes that they look sickly, you don't want to take a ton, but you want to take enough to show the condition, especially in the bed sore case, of the condition of the skin and the problems that they have suffered. Next, bring all the documents that sets out the injured person's health insurance, Medicaid number, Medicare number, and any supplemental insurance. This is very important because in medical malpractice cases, like nursing home cases, if you have an insurance carrier that's paid out monies for the care and treatment, even though it was negligent care and treatment, sometimes they get what's called subrogation. And so we have to make sure that either they waive that subrogation, or we show them they cannot get that subrogation back, or we have to come to a settlement with them on what we paid in subrogation. Sometimes if it's a complicated matter, what I mean by that is you have a large amount that's more than what you actually settled the case for. Our firm sometimes third parties that out. There's groups that specifically do that, but we know what we need to do and how to get that to them and how to get that resolved. That usually comes with a very small cost, not nearly what the amount that's in dispute. So you got to make sure you get all those things taken care of. If you do not get that subrogation taken care of and you settle a case and distribute the money, there is a good possibility that they come out to you as the client and sometimes a law firm with their hand out saying, hey, we still want our money. So you got to make sure you take care of that. Next, if the injured person has unfortunately passed, then bring in the death certificate. The death certificate is what we use to attach the back of the petition for appointment of personal representative, to be able to file any lawsuit, request any medical records, etc. Medical malpractice cases and as well as nursing home cases are both considered malpractice cases to a certain extent. We must get the medical records to make sure that we have a basis for proceeding. There has been untold amount of cases that I've gotten that I thought that looks like a good case. I get it in, go through the medical, or I have the medical reviewed, and there's no case. Also on the flip side, there have been cases that I didn't think was a case, because when clients communicate to you, they don't give you the buzzwords you want to hear. And so they come in and say, oh, okay, I'll set up in the state, I'll get the records, or I have the client go get the records. I get the records in, and after I get the records in, a case that I didn't think was a very good case becomes suddenly a good case or a great case. So it's very, very important that we get the death certificate so we can attach it to the back of the petition to appoint personal representative and obtain the records. Next, in regards to medical malpractice case, no monies are required to be paid up front. They are taken out on a contingency fee basis, even if you've got a gut cinch case, like a fall case, or they're still hard to win. And so what ends up happening there is we take them on a contingency fee basis, and in all med mal cases and in nursing home cases also, you need to have an expert to testify as to the breach of the standard of care. Now there's exceptions and proximate cause and damages. So you can have a standard of care, which sometimes a nurse can testify to that, but you got to have a physician that says that's a proximate cause of their injuries and or death. In getting all that together, you've got to pay monies for those people to testify. I have had on more than one occasion gotten this far, had it reviewed by a nurse or other medical care provider, says there's a good case, then take it to the folks that want to testify at trial, or even myself would look at the records and think it's a good case, spend a bunch of money, get there, they go, no. You've got to make sure that you've got an expert to proceed with the case forward. That being said, we have to spend money for those folks. In the more seriously injured cases, we have to spend more money on more experts, so it can get quite costly after a while. Our office fronts all that money to be able to prosecute that case, and we're very picky on the cases that we take because it's just very, very hard to win. Medical malpractice cases are. Not that we don't, I'm just saying they're very, very hard. That being said, if you think you're a victim yourself of a medical malpractice case, or a loved one is a victim of a medical malpractice case, contact us at the law offices of Craig L. Cook, 479-783-8000, Arkansas and Oklahoma. We take in both states. Or you can contact our office by simply going to my website, craig@lawofficesofcraiglcook.com. You'll have several options. You can send an email straight through that to me. Again, contact us if you think you're the victim of a medical malpractice case or a loved one's a victim of a medical malpractice case, 479-783-8000, or go to our website, lawofficesofcraiglcook.com. Thank you very much.